Denzel Washington stood perfectly composed at the lectern in courtroom 3 of the Supreme Court, his tailored navy suit a stark contrast against the imposing marble columns behind him. Just moments earlier, Chief Justice John Roberts had interrupted his oral argument with an unprecedented challenge. "Mr. Washington, I find it difficult to believe that someone from your background fully understands the constitutional implications of your position." The statement sent shock waves through the packed courtroom. Law clerks exchanged glances, veteran attorneys straightened in their seats, and journalists frantically scribbled notes. But Washington, the award-winning actor who had spent the last 5 years secretly earning his law degree while filming blockbusters, didn't flinch as the 9 justices and hundreds of spectators watched intently. Chief Justice Roberts, with his Harvard pedigree and 16 years leading the nation's highest court, was certain he could expose this celebrity's legal inadequacies. But Washington, armed with a constitutional theory he had developed during his studies and a comprehensive knowledge of case law that would shock the court, was about to transform this condescending ambush into the most memorable oral argument in decades. This wasn't just another Supreme Court hearing, it was Washington's moment to prove that brilliant legal minds can emerge from unexpected places and possibly change American constitutional interpretation forever. Before diving into this extraordinary legal showdown, make sure to like this video and subscribe to our channel so you won't miss our latest coverage of inspiring stories where preparation meets opportunity. The tension inside the Supreme Court had been building since the moment Denzel Washington's name appeared on the YIK docket 3 months earlier, when the renowned actor had filed an amicus brief in Henderson versus Department of Justice, a case involving civil forfeit laws disproportionately affecting minority communities. Legal circles initially dismissed it as celebrity activism. Few realized that Washington had actually earned his JD from Howard University School of Law, studying nights and weekends between film projects, maintaining complete privacy about his educational pursuits. Chief Justice John Roberts, 67, presided over the court with the confident authority that came from a sterling legal career, Harvard Law Review clerk for Justice Rehnquist, Principal Deputy Solicitor General, and nearly 2 decades on the nation's highest bench. Known for his incisive questioning and occasional sharp wit during oral arguments, Roberts had developed a reputation for testing unprepared attorneys with piercing hypotheticals that exposed logical flaws in their reasoning. When Washington was granted 10 minutes to argue in support of the petitioner, a rare honor for someone filing an amicus brief, the legal community buzzed with speculation. Most assumed it was a public relations move by the court, attempting to appear more accessible to ordinary Americans, but those who had actually read Washington's 40-page brief recognized something the chattering class missed. It contained a novel legal argument about the original understanding of the Fifth Amendment's takings clause that challenged decades of precedent. "I can't believe they're letting him speak just because he's famous," whispered a corporate attorney to his colleague in the gallery. "This isn't Hollywood. You can't just memorize lines and expect to convince the Supreme Court." The stakes were enormous. Henderson involved the government seizure of a community center and surrounding properties in a predominantly black neighborhood in Philadelphia, based on a single drug transaction that had occurred on the sidewalk outside. The government hadn't charged any of the property owners with crimes, but had seized millions in real estate through civil forfeit laws. If Washington's argument prevailed, it would dramatically limit government power to seize property without criminal convictions. If he failed, not only would the seizure stand, but his legal theories developed during years of determined study would be dismissed as amateur musings of a celebrity dilettante. The courtroom fell silent as Washington approached the podium. Unlike many first-time advocates who appeared nervous before the court, he moved with the quiet confidence of someone accustomed to high-pressure performances. Still few in the room, perhaps none, anticipated how thoroughly prepared he actually was. "Mr. Chief Justice, and may it please the court," Washington began, his resonant voice filling the chamber without need of amplification. "The Fifth Amendment's provision that private property shall not be taken for public use without just compensation was understood by the founders to require not merely monetary compensation, but also a genuine public purpose and basic procedural protections before the awesome power of government could be deployed against a citizen's property." His opening was eloquent but unremarkable. Chief Justice Roberts, who had been reviewing Washington's brief with skepticism, saw an opportunity to expose what he perceived as superficial understanding. While justices typically allowed attorneys to develop their arguments before questioning, Roberts broke protocol, interrupting just 40 seconds into Washington's presentation. "Mr. Washington," Roberts began, his tone carrying a hint of condescension, "while I appreciate your interest in this case, I find it difficult to believe that someone from your background fully understands the constitutional implications of your position. Your brief seems to overlook 2 centuries of settled doctrine on civil forfeit. A murmur ran through the courtroom at the unusually personal nature of the challenged. Justice Sonia Stomea shifted uncomfortably in her seat. Justice Elena Kagan frowned slightly. Washington paused, meeting the Chief Justice's gaze directly. Those who knew him recognized the calm that always preceded his most powerful performances. Chief Justice Roberts, he replied evenly, I believe my argument is consistent with the historical understanding of the Fifth Amendment as articulated by Justice Thomas in his concurrence in Timms v. Indiana, but perhaps we should examine the textual and historical evidence together. He opened a well-worn copy of the Constitution along with several original sources that he, unlike most advocates, had brought to the podium. Something in his methodical preparation caught Roberts off guard. This wasn't the surface-level celebrity advocacy he had anticipated. What followed was the opening move in a legal chess match that would leave the court and the nation stunned by its conclusion. Chief Justice Roberts, realizing his initial dismissal had failed to rattle Washington, leaned forward with a more substantive challenge. Mr. Washington, your brief argues that the original understanding of civil forfeit was limited to admiralty and customs cases where jurisdiction over property owners couldn't be established, but you've overlooked the 1827 case of the Palmyra where this court clearly established broader government forfeit powers. The question was a trap, one that had ensnared many experienced attorneys. The Palmyra was indeed a landmark case on forfeit, but its nuances were often mischaracterized. Without hesitation, Washington responded, with respect, Chief Justice, I have not overlooked the Palmyra. In fact, on page 23 of my brief, I addressed Justice Story's opinion in detail. He flipped precisely to the page without looking. While the Palmyra did permit forfeit without criminal conviction, it was fundamentally a maritime case involving piracy, whereas Justice Story noted the vessel which commits the aggression is treated as the offender. This fiction made sense in admiralty cases where personal jurisdiction was often impossible to obtain. Washington continued, his voice gaining momentum, but Justice Story never suggested this exception should become the rule for domestic civil forfeit against American citizens who are fully subject to the court's jurisdiction. In fact, I've traced every civil forfeit case decided by this court between 1789 and 1850, all 27 of them, every single one, involved either maritime seizures, customs violations, or piracy. Not one approved the type of land-based seizure from innocent owners that we see in Henderson. The courtroom fell silent. Washington wasn't just familiar with the Palmyra. He had conducted a comprehensive historical analysis that few scholars, let alone practicing attorneys, had ever attempted. Justice Samuel Alito, often sympathetic to law enforcement powers, jumped in. That's an interesting historical observation, Mr. Washington, but how do you account for our more recent precedents? In Bennis v. Michigan, this court upheld the forfeit of a vehicle from an innocent owner. Justice Alito, I believe Bennis was wrongly decided. Washington replied, drawing gasps from the gallery. Directly challenging Supreme Court precedent was a bold move, and I'm not alone in that assessment. Justice Thomas, joined by Justice Ginsburg, despite their different jurisprudential approaches, dissented forcefully. More importantly, Bennis created a tension in our jurisprudence that this case allows the court to resolve. Washington turned a page in his notes. Since Bennis, this court decided Austin v. United States, holding that civil forfeit is subject to the excessive fines clause, and Timms v. Indiana, incorporating that protection against the states. These cases recognize that civil forfeit is quasi-criminal in nature and must respect constitutional limitations. The dynamic in the courtroom was shifting perceptibly. Justices who had initially appeared skeptical were now engaged, several taking detailed notes. Court observers noted that Justice Clarence Thomas, who rarely speaks during oral arguments, was paying unusually close attention. Justice Brett Kavanaugh entered the fray. Your historical argument is compelling, Mr. Washington, but there's a practical concern. Civil forfeit has become an important tool for law enforcement. Are you suggesting we should completely eliminate it? Not at all, Justice Kavanaugh. Washington replied, I'm suggesting that court should restore civil forfeit to its historical boundaries. It remains perfectly appropriate in its traditional contexts, admiralty, customs, and cases where jurisdiction over the property owner cannot be established. But when the government can bring criminal charges against a property owner and chooses not to, yet still seeks to take their property, both due process and the takings clause impose higher burdens. Chief Justice Roberts, clearly surprised by Washington's command of the subject, attempted a different approach. Your brief cites several obscure founding era cases from state courts that most scholars haven't discussed. How can we be confident these represent the mainstream understanding rather than outlier positions? It was the kind of question designed to expose superficial research. Roberts suspected Washington might have cherry-picked convenient cases without broader context. Washington smiled slightly. This was the opening he had been waiting for. I'm glad you asked about Those cases, Chief Justice, far from being outliers, they represent a consistent pattern across multiple jurisdictions from memory. He proceeded to outline the facts and holdings of 8 state Supreme Court cases from the early Republic, explaining how they collectively demonstrated a narrow understanding of legitimate property seizures. Justice Elena Kagan, visibly impressed, interjected, "Mr. Washington, your historical research is remarkable. Did you work with a team of legal historians to prepare this argument?" For the first time, Washington showed a hint of personal pride. "No, Justice Kagan, while I certainly read the leading scholars, the primary research tracing these cases through the archives, examining the original documents, I conducted myself during my law school studies at Howard. And in the years since graduation, a buzz ran through the courtroom. Many there were learning for the first time that Washington's legal credentials were genuine." Chief Justice Roberts, whose earlier dismissiveness now seemed inappropriate, shifted uncomfortably. Justice Sotomayor seized the opening. "Mr. Washington, returning to the case at hand, how would your historical framework apply to the community center seized in Henderson?" Washington turned directly to address her. "Justice Sotomayor, under the original understanding I've outlined, the seizure in Henderson fails constitutional scrutiny on multiple grounds. First, a single drug transaction by a third party on a public sidewalk creates at most a tenuous connection to the property. Second, the government has made no attempt to prove the owners had knowledge of illegal activity. Third, the taking is grossly disproportionate to any harm caused." He paused, then delivered his most powerful point. "Perhaps most fundamentally, this seizure violates the public use requirement of the Fifth Amendment civil forfeit that transfers property to general government funds rather than remedying a specific harm. Cannot satisfy the public use test as the founders understood it as." Washington's argument gained momentum. Court officers discreetly extended his allotted time, a rare courtesy that signaled the justice's engagement. Chief Justice Roberts, now fully attentive, recognized that far from embarrassing Washington, he had inadvertently given him the perfect platform to demonstrate extraordinary legal acumen. The stakes had escalated far beyond the initial confrontation. What began as an attempt to put a celebrity in his place had transformed into a serious reconsideration of constitutional doctrine, and Washington wasn't finished yet. The atmosphere in the Supreme Court had transformed completely. What began as skepticism toward a celebrity advocate had evolved into a masterclass in constitutional interpretation that had captured the full attention of every justice. Washington's command of case law history and legal theory had surpassed that of many veteran Supreme Court litigators. Chief Justice Roberts, recognizing that his initial condescension had been not just inappropriate but embarrassingly misplaced, attempted to recover professional ground. "Mr. Washington, your historical analysis is certainly thorough, but I'm still troubled by practical implications. If we accept your framework, numerous existing forfeitures might be called into question. Have you considered the reliance interests at stake?" It was a legitimate concern, one the court often weighed when contemplating significant doctrinal shifts, but Washington had anticipated this line of questioning. "Chief Justice Roberts, I have indeed considered the practical implications carefully," Washington replied, pulling out a document that appeared to contain detailed statistics. "I've analyzed data from the Department of Justice's asset forfeit program over the past decade. Approximately 87% of current forfeitures would remain untouched under my proposed framework, those involving unclaimed property, customs violations, and cases with criminal convictions." Washington turned a page in his notes. "The only forfeitures that would be affected are precisely those that most offend our constitutional traditions, seizures from innocent owners based on tenuous connections to alleged wrongdoing, often without any criminal charges filed. These represent less than 13% of forfeitures by value, but they cause disproportionate harm to communities like the one in Philadelphia affected by this case." Justice Amy Coney Barrett, who had been listening intently throughout, spoke up. "Mr. Washington, your brief makes an interesting textual argument about the relationship between the Due Process Clause and the Takings Clause that I don't believe any scholar has previously developed. Could you elaborate on that?" The question reflected genuine intellectual curiosity, a sign that Washington's arguments were being taken seriously at the highest level. Justice Barrett, thank you for that question, Washington replied. "While these clauses are typically analyzed separately, the historical evidence suggests the founders understood property protections holistically. When government action deprives citizens of property without meaningful procedural protections, it implicates both clauses." He continued with growing confidence. James Madison, who drafted both protections, wrote extensively about the interconnection between procedural fairness and substantive property rights. In a letter to Jefferson in 1788, he explicitly connected arbitrary seizures to both due process violations and uncompensated takings. Washington reached into his folder and removed a photocopy of a handwritten letter. I took the liberty of visiting the Madison papers at the Library of Congress. While preparing for this argument, this letter hasn't been cited in previous forfeit cases, but Madison clearly states that the seizure of a citizen's lands without proper process or public purpose constitutes a double violence against the right most sacred in ordered society. Justice Thomas, who had remained silent but deeply engaged, finally spoke, a rare occurrence that caused reporters to sit forward in their seats. Mr. Washington, your originalist approach is refreshing. You've persuasively shown that civil forfeit as currently practiced extends far beyond its historical boundaries. But I'm curious, how would you distinguish this case from Venice? Would you have us overturn that precedent explicitly? The question went to the heart of the court's stare decisis doctrine, its reluctance to overturn established precedents without compelling reasons. Washington responded with precision. Justice Thomas, while I believe Venice was incorrectly decided, this court need not explicitly overturn it to rule for the petitioners in Henderson. Venice involved a vehicle used directly in criminal activity maintaining at least some connection to the historical understanding of forfeit. Henderson involves real property with only the most attenuated connection to any crime. The court could distinguish these cases while clarifying that civil forfeit is constrained by both historical practice and constitutional limitations. This nuanced response, respecting institutional concerns while advancing his argument, demonstrated Washington's sophisticated understanding of how the court operated. He wasn't merely making abstract legal arguments, he was providing the justices with a doctrinally sound path forward. Chief Justice Roberts, now fully engaged with the substance of Washington's position rather than his credentials, posed a final question. Mr. Washington, if we were to accept your framework, what specific test would you have us adopt for evaluating civil forfeitures going forward? It was the kind of question typically reserved for the most respected advocates, an invitation to help shape the law rather than merely argue a position. The crowded courtroom recognized the significance of this shift. Washington didn't hesitate. Chief Justice, I would propose a three-part test rooted in original understanding and consistent with this court's more recent jurisprudence in Austin and Timms. He held up three fingers, counting off each element. First, the government must establish a substantial connection between the property and criminal activity, not the tenuous relationship asserted in this case. Second, where the owner is subject to jurisdiction, due process requires the government to either secure a criminal conviction or prove by clear and convincing evidence that the owner had actual knowledge of and consented to the illegal use. Third, the forfeit must satisfy the public use requirement by addressing the specific harm caused, rather than simply generating revenue. Washington concluded with quiet authority, this approach honors constitutional text, aligns with historical practice, provides clear guidance to lower courts, and protects innocent Americans from one of the most severe exercises of government power, the taking of their homes, businesses, and community institutions without meaningful process. As Washington's allotted time expired, something extraordinary happened. Instead of the customary interruption by the Chief Justice announcing, "Your time has expired," there was a moment of complete silence in the courtroom. Several justices were still taking notes, others sat back, visibly processing what they had heard. Finally, Chief Justice Roberts spoke, his tone markedly different from his initial intervention. "Thank you, Mr. Washington. Your argument has been exceptionally informative." The simple acknowledgement carried unmistakable subtext, a recognition that Roberts' attempt to embarrass Washington had backfired completely, instead revealing a legal mind of remarkable capacity and preparation. As Washington gathered his materials and returned to his seat, the government's attorney approached the podium looking visibly shaken. The dynamic of the case had shifted fundamentally. What began as a routine defense of government power had transformed into an uphill battle against a constitutional framework that had resonated with justices across the ideological spectrum. Legal reporters in the courtroom immediately recognized they were witnessing a historic argument, one that might reshape constitutional doctrine while also challenging assumptions about who belongs in the legal profession's most prestigious venues. The aftermath of what quickly became known as the Washington argument spread through legal and cultural circles with unprecedented speed. Within hours, law professors were assigning the oral argument transcript to their students. Constitutional scholars from across the ideological spectrum weighed in, many expressing surprise and admiration for the depth of Washington's analysis. CNN legal analyst Jeffrey Tabine delivered perhaps the most succinct assessment: "I've covered the Supreme Court for over 20 years and I've never seen anything quite like this." Denzel Washington didn't just hold his own against the Chief Justice. He delivered what may be the most compelling originalist argument against civil forfeit ever presented to the court. The following morning, hashtags like legal scholar Denzel and dark Denzel teaches the chief trended across social media platforms. Clips of Washington citing obscure Madison letters and reciting early American case Law from Memory circulated widely, garnering millions of views. A generation raised on Washington's film performances discovered a new dimension to their admiration 3 days after the argument. The New York Times published a feature revealing details about Washington's legal education that had previously remained private. According to the article, Washington had completed his JD at Howard University School of Law with highest honors, studying nights and weekends while maintaining his acting career. His professors described him as an exceptional student with particular interest in constitutional history and civil rights. He never wanted special treatment, said Professor Marcus Johnson, who taught Washington's constitutional law course. Most students had no idea who was sitting next to them for the first few weeks. He was just another dedicated student with a passion for justice, albeit one with an unusually commanding classroom presence. The article revealed that Washington had funded scholarships for law students from underrepresented backgrounds but had requested his name not be attached to the financial support. His legal studies had been motivated by a long-standing interest in justice reform and a desire to contribute substantively beyond his platform as a celebrity. Legal blogs and podcasts dissected every aspect of the oral argument. Particular attention focused on Chief Justice Roberts' initial dismissive comment and how dramatically the dynamic had shifted once Washington demonstrated his expertise. Court watchers noted that Roberts had grown increasingly respectful as the argument progressed, eventually engaging with Washington as an intellectual peer, rather than an interloper. What we witnessed was a real-time recalibration of assumptions, said Nina Totenberg on NPR's Morning Edition. The Chief Justice clearly expected to find a dilettante, and instead discovered a brilliant legal mind. His evolution during those 50 minutes teaches us something important about preconceptions in the legal profession. The professional legal community's response was equally significant. The American Bar Association invited Washington to deliver the keynote address at its annual conference. Law school applications from underrepresented minorities increased 34% following the widely publicized argument, with many applicants citing Washington's example as inspiration. Washington himself maintained characteristic humility in his limited public comments when asked about the argument by a reporter at an unrelated film premiere. He simply stated, "The law, like acting, rewards thorough preparation. I'm grateful the court gave me the opportunity to present an important constitutional argument, and I hope their decision advances justice." 6 weeks after oral argument, the Supreme Court issued its opinion in Henderson v. Department of Justice. In a surprising 7-2 decision, the court ruled for the petitioner, significantly restricting the government's civil forfeit powers along lines similar to what Washington had proposed. Chief Justice Roberts assigned himself the majority opinion. A say choice many court observers interpreted as a gracious acknowledgement of his initial misjudgment. Roberts wrote, "After careful consideration of the historical record and constitutional text, we conclude that civil forfeit as currently practiced has expanded far beyond its original boundaries. While civil forfeit remains a valid tool in appropriate contexts, the Constitution does not permit the government to seize private property from innocent owners based on tenuous connections to alleged wrongdoing, particularly whereas here the property serves important community functions in an unprecedented move." The opinion directly quoted Washington's oral argument 4 times, including his 3-part test, which the court largely adopted. A footnote specifically commended counsel for amicus curiae for exceptionally thorough historical research that illuminated founding-era understandings of property protections. Justice Thomas wrote a concurring opinion that went even further, calling for a complete re-examination of civil forfeit doctrine in light of original understanding. Justice Sotomayor's concurrence emphasized the disproportionate impact of forfeit practices on disadvantaged communities, citing statistics Washington had provided during argument. Perhaps most remarkably, Chief Justice Roberts added a personal observation in the final paragraph of the majority opinion. This case reminds us that legal wisdom can come from unexpected sources, and that our system of justice is strengthened when diverse voices and perspectives are fully heard. The court benefited greatly from the thorough advocacy and historical insights provided by all who participated in this important case. The practical impact of the decision was immediate and far-reaching. Within months, several states reformed their civil forfeit laws to comply with the new constitutional framework. Property worth millions was returned to community organizations and innocent owners who had been caught in aggressive forfeit operations. Law enforcement agencies began focusing on forfeitures tied to actual convictions rather than pursuing the more tenuous claims that had become common for Washington. Personally, the experience opened a new chapter in his already distinguished career. While he continued his work as an actor and director, he also established the Washington Justice Initiative, a non-profit organization providing legal representation to communities affected by civil forfeit and related property rights issues. Several leading law schools invited him to deliver guest lectures on constitutional history 6 months after the decision. Washington and Chief Justice Roberts appeared together at a Georgetown Law School forum on civic education, their discussion marked by mutual respect and even occasional humor about their initial courtroom encounter demonstrated how adversarial legal proceedings can ultimately advance understanding when conducted with integrity and thorough preparation. Roberts acknowledged publicly what many had observed privately. Mr. Washington taught me a valuable lesson that day: never to confuse celebrity with capability, never to assume that unconventional paths to legal knowledge are less valid than traditional ones. His argument in Henderson will be studied by law students for generations to come. Washington responded with characteristic dignity: the beauty of our legal system when it functions as intended is that arguments stand or fall on their merits, not on the identity of those who make them. I'm grateful the court was willing to engage seriously with the constitutional issues in Henderson regardless of the unusual messenger who brought them. The exchange, widely shared across social media and featured in law school orientation materials, became a powerful symbol of how preconceptions can be overcome through preparation, perseverance, and the courage to speak truth to power. In classrooms, courtrooms, and public discourse across America, the story of how a Hollywood icon humbled the Chief Justice not through celebrity but through scholarly excellence became a modern parable about judgment, opportunity, and the ongoing American struggle to create a legal system where ideas truly matter more than identity. Thank you for watching this remarkable story about Denzel Washington's Supreme Court triumph. If you found this account of legal brilliance and preparation inspiring, please hit the like button and subscribe to our channel for more stories of justice, perseverance, and unexpected excellence. Leave a comment below with your thoughts on how preconceptions can limit our recognition of brilliance and unexpected